The Supreme Court just struck down Trump's birthright citizenship order, and the ruling wasn't nearly as close as expected. In the next several minutes, I'll break down exactly what the Supreme Court decided in Trump versus Barbara. I'll show you why the vote split in a way almost nobody predicted. I'll explain what it means for hundreds of thousands of families across the country, and I'll tell you what President Trump says happens next, and whether that's even realistic under this ruling. On Tuesday, June 30th, 2026, the Supreme Court ruled in Trump versus Barbara. The justices struck down President Trump's executive order that tried to end automatic citizenship for babies born in the U.S. to undocumented or temporary visa parents. The case reached the justices from a federal district court in New Hampshire on an expedited path that skipped the usual appeals court step. It's the final major opinion of the court's term, and one of the most consequential rulings in decades on what it means to be an American citizen. Let's start with the outcome. The vote was 6-3 to strike down the order. But the reasoning splits differently, 5-1-3. That distinction matters, so let's slow down on it. Chief Justice John Roberts wrote the majority opinion. He was joined by Justices Sotomayor, Kagan, Barrett, and Jackson. Those 5 justices held that the executive order violates the Constitution itself, specifically the 14th Amendment's Citizenship Clause. That clause reads, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States." It was ratified in 1868, in the aftermath of the Civil War. Its original purpose was to overturn the Supreme Court's notorious 1857 ruling in Dred Scott versus Sanford, which had denied citizenship to Black Americans, including those who had been freed from slavery. The 14th Amendment was written to guarantee that anyone born on American soil, regardless of their parents' background, would be a citizen from birth. Roberts leaned heavily on a case from 1898 called United States versus Wong Kim Ark. That case involved a man born in San Francisco to Chinese immigrant parents. At the time, federal law barred Chinese immigrants from becoming naturalized citizens. Wong Kim Ark's parents lived and worked lawfully in San Francisco for more than 2 decades. When he traveled to visit family in China and tried to return home, immigration officials blocked him at the border, arguing he wasn't a citizen because his parents weren't. The Supreme Court disagreed. The justices ruled that he was a citizen by birth, regardless of his parents' immigration status. That decision has stood, largely unchallenged, for well over a century. Roberts wrote that the court has repeatedly understood the Wong Kim Ark rule to guarantee citizenship broadly ever since, and said there's no reason to depart from that view today. In his own words, citizenship, then and now, was the right to have rights, to freely participate in our political community. He added that the framers of the 14th Amendment extended that promise to every freeborn person in this land, and that the court is simply keeping that promise. To show how deeply this principle has been embedded in American law, consider this. Even during World War II, when the U.S. government forcibly detained Japanese immigrants and their families in internment camps, babies born inside those camps were still automatically recognized as U.S. citizens, because they were born on American soil. That's how consistently courts have applied the birthright rule, even in the darkest chapters of American history. Now let's talk about the order itself. Executive Order 14,160 was signed by President Trump on January 20th, 2025, his first full day back in office. It was titled, "Protecting the Meaning and Value of American Citizenship." The order instructed federal agencies to stop automatically recognizing citizenship for children born in the U.S. if their parents were in the country illegally or present only temporarily, such as on a tourist or student visa. Under the order's own terms, it was set to apply 30 days after signing, and only to babies born after that point, not retroactively. It never actually went into effect. Multiple federal judges reviewed it almost immediately and blocked it, one calling it blatantly unconstitutional. 2 federal appeals courts later upheld those blocks as the legal fight continued. So functionally, this order sat frozen in the courts for the entire year and a half between signing and Tuesday's final ruling. Why did it take that long to get a final answer? Because of how the challenge was structured. This wasn't a single straightforward constitutional test from day one. It took a detour through a separate, high-stakes fight over how far federal judges are allowed to go when blocking a president's policy nationwide. We'll walk through exactly how that detour worked next, because it directly shapes how today's ruling actually plays out on the ground. Here's where the procedural path gets important, and where a lot of coverage oversimplifies things. When lower courts first blocked President Trump's order, They did it using something called a nationwide injunction. That's a court order that blocks a policy for everyone in the country, not just the specific people who filed the lawsuit. The Trump administration pushed back hard on that tactic, arguing individual district judges shouldn't have the power to freeze federal policy for the entire nation based on one lawsuit. In June 2025, the Supreme Court agreed with that argument in a case called Trump versus CASA. The vote there was also 6-3. The justices ruled that federal district courts generally can't issue those sweeping nationwide injunctions anymore. But, and this is the key point, that earlier ruling never touched the actual birthright citizenship question. It was purely about the power of judges to block policies, not about whether the birthright citizenship order itself was legal. So what happened next? On the very same day the CASA ruling came down, the ACLU filed a brand new case in New Hampshire. Instead of asking one judge to block the policy nationwide, they asked the court to certify a class action, a lawsuit representing an entire group of affected children, and to grant a class-wide injunction covering everyone in that group. That's the legal workaround the CASA decision forced onto challengers. The lead plaintiff in that case is known publicly only as Barbara. Court filings describe her as a Honduran national. She's identified only by her first name because of stated safety concerns for her and her family. That New Hampshire case, Barbara versus Trump, is what eventually reached the Supreme Court, and it got there fast, on what's called certiorari before judgment. That means the Supreme Court agreed to skip the normal federal appeals court step entirely and rule directly, given how urgent and significant the issue was. Oral arguments happened on April 1, 2026. The session ran 2 hours, longer than a typical Supreme Court argument. President Trump himself showed up in person to watch, becoming the first sitting president in modern history to attend Supreme Court oral arguments. During those arguments, the administration's lawyers leaned heavily on the idea of domicile, arguing that Wong Kim Ark's parents were effectively long-term, domiciled residents of San Francisco, and that this mattered to the outcome of that earlier case. They argued the same domicile logic should apply here, distinguishing lawful long-term residents from people only temporarily or unlawfully present. Now back to Tuesday's actual ruling. Justice Brett Kavanaugh didn't join the 5-justice constitutional majority. He took a different route entirely. He agreed the executive order should be struck down, but he grounded that conclusion in federal statute, not the Constitution. Specifically, he pointed to an existing federal citizenship law, 8 U.S.C. Section 1401A, and argued the order conflicted with that statute as written. He noted that Congress could, consistent with the 14th Amendment, pass new legislation carving out exceptions, but that Congress simply hasn't done that yet. Justice Ketanji Brown Jackson filed her own separate concurring opinion as well, joined in part by Justice Sotomayor, adding further historical reasoning in support of the majority's constitutional conclusion. Reaction came quickly. Cecilia Wang, the ACLU's national legal director, argued the case in April. She called the ruling a win for the American people. She said the plaintiffs had been living under this cloud of uncertainty for more than a year and are now relieved. Wang, notably, is herself a birthright citizen, born to Chinese immigrant parents. President Trump reacted within hours on social media. He wrote that the ruling was too bad for our country, but said Congress could easily make it up through legislation instead. He added, quote, "No long and unwieldy constitutional amendment is necessary." We'll come back to whether that's actually accurate at the end, because most legal scholars strongly disagree with that assessment. But here's the part most people are missing. The dissent wasn't one unified block. It's being reported that way in a lot of headlines, but it's more complicated, and understanding that complication tells you a lot about where this fight goes next. 3 conservative justices dissented from the majority's constitutional holding: Thomas, Alito, and Gorsuch. But they didn't all argue the same thing, and the differences between them are significant. Justice Clarence Thomas wrote the lead dissent, 91 pages long, joined by Justice Gorsuch. Thomas argued the 14th Amendment's core purpose was to secure citizenship for formerly enslaved Black Americans specifically, and that the amendment's text requires genuine domicile, an established permanent residence, not merely physical presence in the country at the moment of birth. He wrote that the Civil Rights Act and the Citizenship Clause guaranteed citizenship to people born and domiciled in the United States, but not to those who weren't domiciled here. He directly called the Chief Justice's historical account not historically accurate. Justice Samuel Alito wrote his own separate dissent. He called the ruling a serious mistake. He argued the majority's interpretation grants citizenship on virtually everyone who happens to be born in this country, including children of so-called birth tourists, people who travel to the U.S. specifically to give birth and then leave. He described the result as a medieval rule and pointed out that the United Kingdom, where this legal concept originally came from, has since narrowed its own citizenship laws to exclude many similar cases. Alito went further, describing the case overall as one of the most significant the court has decided in years, even while strongly disagreeing with the outcome. But Justice Neil Gorsuch's separate dissent is where this actually gets nuanced, and where a lot of coverage misses something important. Gorsuch draws a sharp, specific line that Thomas and Alito don't draw the same way. He distinguishes between children of temporary visitors like birth tourists just passing through the country and children of undocumented immigrants who've built long-term lives here, put down roots, and effectively made the U.S. their home. Gorsuch wrote about two competing historical readings of the Citizenship Clause, one rooted in the English common law idea of jus soli, meaning citizenship simply follows the place of birth, and another he described as a distinctly American view, one that extends citizenship to children of parents who have made this country their permanent home, regardless of their race, religion, or national origin. Gorsuch leans toward that second reading. What that means practically. Gorsuch's actual disagreement with the majority is narrower than Thomas's or Alito's. He appears far more sympathetic to citizenship for children of long-term undocumented residents than he is to children of short-term visitors or birth tourists. That's a meaningfully different position than his two dissenting colleagues, even though all three technically landed in the same three-vote dissent. It's also worth noting the administration's legal team pointed to an older, related precedent during the broader legal fight, an 1884 case called Elk versus Wilkins. In that case, the court ruled that a Native American man born on a reservation wasn't automatically a birthright citizen, because tribal members at the time were considered to owe allegiance to their tribal nation, not the United States, comparing that status to children born to foreign diplomats. The government argued this showed that, subject to the jurisdiction, has never been an absolute, universal rule. Tuesday's majority opinion effectively rejected extending that logic to the situation of undocumented or temporary immigrants. Now here's some outside legal analysis, and I want to be clear this is analysis, not part of the court's actual holding. Legal scholars widely agree that because 5 justices grounded this ruling directly in the Constitution, not in ordinary federal statute, undoing it isn't something Congress can simply legislate away. It would most likely require a formal constitutional amendment. That's a direct contradiction of what President Trump suggested in his post-ruling statement. On the scale of impact, various estimates from groups like the Migration Policy Institute have put the number of U.S.-born children who could have been affected annually by this order anywhere between roughly 150,000 and 255,000, depending on the methodology and time period used. That range itself has been reported inconsistently across outlets, so treat any single specific number with some caution, but by any measure, we're talking about a policy that would have touched hundreds of thousands of children every single year had it taken effect. Let's circle back to Trump versus CASA, because it's the direct procedural ancestor of Tuesday's ruling, and you can't fully understand today's outcome without it. CASA was decided almost exactly 1 year earlier, on June 27, 2025. In that case, also by a 6-3 vote, the Supreme Court restricted federal judges from issuing nationwide injunctions in most circumstances. That single procedural ruling reshaped how virtually every major legal challenge to a Trump administration policy has been litigated ever since, forcing groups like the ACLU to pursue class action lawsuits instead of simple nationwide injunctions. Some legal observers argue that, ironically, the CASA ruling may end up producing more durable outcomes for challengers than nationwide injunctions ever did. A class action ruling like the one in Barbara doesn't just block enforcement temporarily, it can result in a full merits decision, like the one we saw Tuesday, that settles the underlying constitutional question permanently for the entire class. That's a very different and arguably stronger form of legal protection than a temporary injunction that could later be lifted or narrowed on appeal. So what happens now? President Trump is publicly calling on Congress to pass legislation restricting birthright citizenship. But as we just laid out, with 5 justices grounding Tuesday's ruling directly in the text of the Constitution, most legal scholars say ordinary legislation simply won't be enough to undo it. Changing this would almost certainly require a formal constitutional amendment, and that means 2/3 support in both the House and Senate, followed by ratification from 3/4 of all 50 states. That is an extraordinarily high bar, one that hasn't been cleared in more than 3 decades. Watch for 2 things over the coming months: whether congressional Republicans actually introduce a birthright citizenship bill this summer, despite scholars saying it likely won't survive a constitutional challenge on its own, and whether any serious push for a constitutional amendment gains real traction, or quietly fades, the way most amendment efforts eventually do. For now, this ruling closes the legal door the administration spent 1.5 years trying to open. So here's my question for you. Do you think Congress will seriously attempt a constitutional amendment on this, or is this fight effectively over? Let me know in the comments below, and if you want to understand exactly how the Supreme Court's rules on nationwide injunctions are reshaping legal fights across the country, go back and watch our breakdown of Trump versus CASA next.